Welcome to the Information Commissioner's Office. If you want to use our Welsh language service, please press 9. If not, please hold. We don't audio record calls to this helpline. For information about what we do with personal data, please visit our website at ico.org.uk/privacy-notice. Our helpline is for organisations, people who work for themselves, and for members of the public. Please note, we will treat all people with courtesy and respect, and we expect the same. If anyone behaves in an unreasonable way to our staff, we will bring the call to a close. To help get you through to the right team, please select from the following 3 options. If you know the extension number of the person you want to speak to, please press 1. If you're calling from an organisation, a small club or association, you're a sole trader, or you work for yourself, please press 2. If you're a member of the public, please press 3.
Number 3.
Here are your 3 options. To discuss an inquiry or complaint you've already sent to us, please press 1. To discuss a new inquiry or complaint with us, please press 2.
2.
We're now transferring you to a member of our team. We regularly update our website with new advice and guidance. Please visit ICO.
Good afternoon, Information Commissioner's Office. Dan speaking. How can I help?
Yes, hello. I'm a member of the public and I'm making some general inquiries. I was wondering if you can able to assist me.
I can help as much as I can, yeah.
Okay, when I started this call, it said that if anybody behaves in an unreasonable manner, you can end the call.
Yes.
And I just wanted to get some clarification on what constitutes as unreasonable behaviour.
It's kind of a bit of a broad scope. Examples would be if someone's rude or abusive to us, we will terminate the call.
Mm-hmm.
What would also be unreasonable is if we've provided our advice to someone and we've kind of gone through the whole issue with them, we've provided our advice, and then they keep asking the same questions in the call, and we've already answered all the issues and we've addressed all the points. Continuing that conversation would be unreasonable. So in that circumstance as well, we would potentially terminate the call at that point as well, because we've kind of gone. So that it's those types of things.
Okay. Would it so the specific conduct I wanted to say is that if I am I know the fact that you don't record this call. If I am recording this call and I make you aware of it, and would that be?
Wouldn't be unreasonable.
Okay.
That wouldn't be unreasonable.
Okay.
So yeah, because you're entitled to, I'm sure you know this already, but you're entitled to record the call.
Okay.
Absolutely.
Okay. And
so yeah.
So thank you for that. And secondly, if I then, without your permission, look to publish it on YouTube or Facebook, have I crossed the line there?
That would depend.
Okay.
It would depend on in terms of if the purpose of you doing that was to intimidate or harass any individual person. I know. I'm not saying that's what you will be doing. I'm saying that in that circumstance, it probably would be unreasonable. But if you're just doing it, then
no. If the purpose, I'll explain the purpose. If the purpose of doing that would be for the purposes of publishing it for other people's attention, the information that you provide,
that wouldn't. As I say, if it was for anything other than to intimidate or harass an individual, then it wouldn't be unreasonable.
Oh, thank you very much. That's so.
We we wouldn't stop it happening.
Okay, that's excellent. So I just clarified that, and just for your understanding, I just want you to know that I am recording this conversation, and the purpose of me recording this conversation is to forward the advice that you're giving me to other people, so to better educate them about the questions that I'm looking to raise with yourself today. Okay. All right.
Yeah, that's fine.
Okay, so the question I wanted to ask was specifically focused in on making a subject access request and the exemption of requiring an extension of time due to complexity. So
Okay.
nothing else. That's the purpose of my call today, just to focus in on this exemption that applies. Now, I just wanted to know under what circumstances, what constitutes what circumstances justifies that
Complexity.
Yeah.
Yeah. So, the complexity thing is a new thing that came in with the new law. So, I mean, it's what is the bar. Essentially, the bar we've set for it is very high,
Okay.
and it's not really. As far as I'm aware, it's not where our view is hasn't actually been challenged in court or anything. So there's not any legal precedent that anyone that either side, either us or them, can kind of properly point to and go, that's where it lies. So we've got our bar is very high. So basically, complexity can't just be purely about the amount of information that's requested. So, you know, if I go to my council and go, give me everything you've got on me, there's potentially quite a lot of information there. They can't just say, well, because it's, you know, like 1,000 pages. That's because it's 1,000 pages, it's complex. They can't do that. That wouldn't be complexity. It relates more to, okay, is the information that's been requested, are there lots of different exemptions that could apply to that information? So do they then need to kind of go through it line by line, looking at one exemption and going through it line by line? And then do they need to go through it again, looking at another exemption? Do they need to kind of speak to legal advisors? Is it complex enough where they actually need to kind of get specific legal advice on a matter? Think on how they need to be doing things. That's where it would start to potentially go more into complexity. In practice, you know, from my experience, I've never had a case where where an organisation said it's complex that we've actually agreed with. Where we've got, if you know what I mean, because the bar, as I said, the bar is high for it. So it's really one of those where it's like, okay, like so a lot of requests that most organisations deal with are fairly what we'd call routine stuff. You know, so like you call your bank to discuss something, got this problem that goes over months, and it's like, I'd like a copy of the call recordings for the last 6 months. That's we'd consider that fairly routine request. That's not complex. So yeah, it obviously we deal with them on a case by case basis. So it's a bit. It would depend on certain things, but really the things that need to be considered are, you know, it's about the legal complexity of the request, as opposed to, you know, it's complex because there's loads of information. It's all about that request. There's lots of different legal complexities to that request that that as an organisation we need to consider. So obviously then that could take more than a month basically to kind of get through all those things. So
Dan, I think you've been excellent in answering that reply. That is exactly my understanding of what the legislation is. Now, obviously, with regards to complexity, what the example that I give is that, take for example your relationship with Google. Now, you know, you provide a lot of services from Google. You know, you do Google searches, email, you may do YouTube videos. Now, that is a very complex domain. But however, they don't have that exemption. They have to still comply within a month. And they routinely do. They have automated processes. So, I mean, I'm in full agreement with yourself now. Just to break it down with regards to the call recording. So this is exactly the reason that I've called up today. All right. So I made a request with 2 different organizations. One organization is an organization that's limited in jurisdiction, like a district. like a council area or a catchment area. The other organization is a national organization. And I've asked them the same question. I would like all my call recordings. All right. The first one, the national organization, which is, as you can appreciate, like yours are a national organization, anybody's ringing you up. And so if I was to ask for this call recording, which I know you don't record, but having said that, if you are a national organization and you are call recording, then you're not saying that that's complex. So the national organization have complied within the statutory time period. However, the local organization have said that we now feel that this is we are permitted to do an exemption because we can't connect your call with the records and so on and so forth. And I wrote them back stating that, well, that is irrelevant because, how you're internally defined your organizational structure, how the data is stored, that's not up to me though, is it? I mean, you could have designed a better system. So that does not necessarily make it complex. So are we in agreement that simply because they've recorded calls,
just like if they're call records in a system where it makes it harder to pull those individual calls out to put them on an MP3 file
yes,
to email out, if that's their argument,
yes,
that wouldn't be. You're right. That wouldn't really meet complexity because it's about, as I say, it's about the legal
yes,
complexity
okay,
of the SAR in terms of redactions and exemptions that might
okay,
apply. So it's not. So just because information has been held on us. So for example, if you go to again with the council, if I go to my council and ask for information, they might have stuff there that's held in an archive warehouse.
yeah,
That's going to take some time to kind of get access to and to find it and pull stuff out.
mm-hmm.
That's still not complex.
Yeah.
If you see what I mean, like that.
Yeah.
Like, there's obviously it's more complex than just kind of doing a quick search like Outlook or something.
Yeah.
But it's still not complex, and it's still not what the purpose of that exemption is for. So it still wouldn't apply in that circumstance. If they're saying, it's a bit more difficult for us to pull that through.
Yeah.
As you say, it's like, well, that's not your problem.
Yeah.
Part of when our guidance in terms of when organisations are setting up new systems and new processes for doing stuff, one of the things we tell
for applying an exemption is to say that, it's complex because I've got other work commitments and I can't do it within the time period. So
that wouldn't apply either.
That's
because again, our perspective is, in deals with councils, I mean, obviously councils, there's potentially staffing issues at councils and stuff like that. For us, it's like, well, we understand that, but as an organisation, that's your responsibility as a data protection officer or whatever to actually go to the board and go, look, you need to give us enough staff and enough financing and enough funding to get that staff to be able to meet our legal requirements. It's a legal requirement to provide a response within a month unless it is that legally complex matter. But essentially the rule of thumb is in 99% of cases, it's not complex, so it needs to be provided within a month. You need to be making sure that is able to be done. In whether that's with you've got a good database that you can easily navigate and pull the information through, and since there's enough staff to be able to do that. So it's not an excuse for them to say. As a result, I mean, we were a bit more lenient with councils and like NHS and stuff during like the lockdown.
Yep.
Because it was like, especially in the first few months, it's like, yeah, we get like there's obviously a public health issue going on. So it's like that will be a bit of a drain on resources. So it still doesn't mean it's not being a breach, but we'll kind of not really.
Okay. Yeah.
We'll not really do much more requirements, but it's still a breach. But
okay.
We're at the point now where it's like, look, you need to have those staff in place. So it wouldn't them saying we've not got enough staff or the systems aren't good enough or anything like that. That's not complex.
Okay, no, I understand.
From our definition of it.
And I fully agree with you once again, and that's the second kind of pretext that I've been given for an extension of time. Now, the third pretext, or the third one, is in relation to asking for an extension of time. And as you can appreciate, if it's like medical records or physical records in an archive storage, that the reality is that does take time. But irrespective, they have to be data compliant. But having said that, where information is completely in a digital format, so I've communicated to them not in letters or anything like this, physical. It's all digital. All right. They've asked for an extension of time because, once again, stating complexity, taken a 2-month extension and then still failed to comply within that 2-month time extension and asked and required further time. Now, where does that fall within the realms of the data protection legislation?
Yeah, can't do that. The maximum is that extra 2-month extension.
Yeah.
So that's make it 3 months. That's the maximum amount of time that can be taken. So they can't then take any further time than that.
I mean,
legally they've got that time. But also, if they said, for instance, for rightly or wrongly, we feel it's complex, so we're going to add an extra month onto this.
Yep.
They then can't, at the end of that extra month, turn around and go, we still can't do it, it's still complex, so we're going to take the other month. They can't do that. It's a one and done thing.
Okay.
So if you they can't, even if it was within that kind of 3-month period.
Yep.
If they require an extension and they're saying it's going to be an extra week or whatever it is, you've got to meet. That's the one they've got to meet. They can't then extend it again.
Yeah, they can't they can't change the goalpost at each juncture. They just can't keep on changing the goalpost. Like,
because at that point, what we'd start to feel is that now the legislation, the way it's worded is, it needs to be provided without undue delay, and in any case within a month or an extra 2 months if it's complex. Yeah. So we'd then start to feel that's an undue delay, where you're just, there's no reason there's no reason to have that going on.
Okay.
And it's a breach anyway because it's outside that 3 months thing, but then we'd also start to be like,
yep. Thank you, Dan. Thank you, Dan. That just clarifies the thing. So the last point I wanted to raise is this, and this is the end. Then I'm going to be looking to end the call today. So the last point I wanted to raise is, you make a subject access request. The organization says, yeah, okay, fair enough. We'll comply. So they acknowledge the subject access request as being valid. They then, after a month time period, they then said, well, actually, this is turning out to be a bit more complex than we initially anticipated. So we want a 2-month extension. So you say, okay, take your 2-month extension. After the 2-month extension, what grounds can they have to invalidate the subject access request and say, well, actually, this whole
we're going to refuse it.
Yeah, we're going to refuse it now, because my argument would be that.
What I'm about to say, I feel like is probably what your argument would be, which is the first thing in the process of when an organisation receives subject access request, the first thing that they need to do is it valid?
Yes.
So do we have all the information that we'll need in order to get the information? So
hello?
Anyone to verify the identity.
Dan, sorry, Dan, you just broke up. Can you just repeat that last sentence, please?
Yeah, will do. So they need to kind of consider straight away: do we need any more information? Do we need to get extra information so we can locate an individual's account or whatever else? And then after that, the next step is it actually valid? So those are the two, like, straight away, those are the two things. And obviously, as you know, a valid request is if someone's asking for information that is their personal data. If someone's asking for personal data, that is a valid request. So, whether or not it might fall under an exempt, you might then find it's exempt. There's exemptions that apply to it or whatever else. The request is still valid. They can't then. So the first things would be, like, do we need to review it? It shouldn't take. Unless in an exceptional circumstance, it should not take more than a month to work out whether or not you're going to provide that information or not. And like an exceptional circumstance will be like, there are exemptions that apply to refusing requests. Theoretically, and it's only theoretical, I can't really think of an example, but theoretically it might be that the whole issue is so complex that actually whether on that exemption about those exemptions that apply may be that complex in the specific case that it does take a bit of extra time to work it out. Otherwise, no, you can't just kind of go, yep, we'll do it, we need a bit more time, and then say, no, actually, we're going to refuse your request. I'd kind of feel on a general level that wouldn't be appropriate, because those are like the first two things that you need to be doing before you start finding the information is.
Yeah, Dan, you
have enough information to find it. Do you need any more, or is it actually valid?
So Dan,
so they can't. Then it shouldn't really be 3 months or whatever of waiting and then saying, oh no, we're not going to do it.
That's perfect. You've answered my questions as my understanding of the legislation is, and you've answered them very eloquently. You've given the right. I'm very happy with the response you've given. That brings an end to my inquiries today with yourself. I'm happy with the responses that you provided, and because obviously the last inquiry that I've made is that it surely can't be right that it takes 3 months later to find out actually you're not going to get your data. That seems just seems wrong to me. So what I'm
as I say, like broadly, yes, unless there is unless like they could demonstrate that they needed that time to really drill down into the legal complexities of the exemptions that they're applying. But I can't really think of an example of that where
and just one final point, and if they have failed, I am within my rights to bring that situation to yourself, or alternatively I'm in a position to take legal action myself as they have violated the laws. And so just wanted to clarify that.
You can make a complaint to us. You can also at the same time or alternatively seek a judicial remedy through the courts on that. So you can do either or both, basically, of those things. They're the options that are available to you.
Okay, thank you, Dan. That's going to bring an end to our call today. Just for your clarity of information, as I explained, I have recorded the call today. The purpose of recording this call was simply to forward it on to the parties, the organizations in question. It's not going to be in the public domain. I have a YouTube channel that I'm going to be uploading it to, just for the purposes that the other organizations can take the advice.
I'm just going to clarify as well, for the purpose of recording stuff as well, the helpline is for general advice, which I've given. I can't give any specific kind of.
Yes.
It's advice. It's not our view necessarily. It's not the same thing as an outcome as a result of a complaint. So theoretically, if you were to make a complaint, we may find that the organisation.
Yes, I understand. I've only. I understand. Just to cover yourself, that's fair enough. But I'm not giving you a specific example. I just want to. I'm basically.
We're speaking generally, but I'm just confirming that. Obviously.
I'm just making you aware that I'm going to take your advice and package it and give it to somebody else. Save them the time of contacting you or seeking further clarity. Just for your peace of mind and understanding. I'm not trying to harass or intimidate you. I'm just trying to be open and transparent. And that's the purpose of the recording the call today, simply to forward it onto another organization so they're fully aware. Because I think, just one final point, the national organization that I requested recordings from, they came back to me and said, well, we're not happy with you covertly recording and publishing things, because that violates the rights of the employees' privacy. Now, my argument is that there is no expectation of privacy for an employee facing doing a public service like yourself. You're now, so is that correct? Isn't that there's no expectation of privacy in a
it's not so much whether there's an expectation of privacy, but under data protection law, which is obviously the only thing I can advise on. Under data protection law, personal data processed by an individual acting in a personal capacity and not as like a professional,
yes,
not in a work-related capacity. Any processing of personal data by that individual acting in that capacity does not come under the scope of the legislation. So, yeah, an individual is entitled to record a phone call, because that wouldn't necessarily be an infringement of privacy, because that processing is for a personal purpose. It's not as a professional thing. So the scope of the legislation and the requirements of the legislation wouldn't apply in the same way that you or I, crowded street or whatever.
Yeah, that's it.
We can film in the crowded street. We can take pictures.
Yep.
We can take a little video, do a little video blog.
Yep.
And there's people walking past
Yep.
and all that type of stuff. You don't they can't turn around and go, well, I've not given my consent,
yes,
or anything like that, because it doesn't matter, because it's in processing it in a personal capacity, and
Yep.
therefore the scope of the legislation doesn't apply. So yeah, you are entitled to record those calls.
I just want to say, on a personal level, I found you exceptionally good at your understanding of the legislation and the assistance that you provided me with. But I just wanted to ask one final question, is that, let's just say, for example, that you're not happy personally with me recording this call, all right? And you're not even happy, furthermore, you would ordinarily, if I would ask you for consent, you would refuse to give me consent. And furthermore, you're not happy with the fact that you're going to work at the ICO and somebody's recording you and publishing this call recording onto YouTube without your permission. And you tell that to your employers, like, well, actually, I'm not happy with this. All right. What remedy do you have available to you?
I mean, as I've kind of referenced earlier, it's the only time as I can really think of where that would be an issue, especially the ICO, that we'd do anything about it, would be if it was felt that it was harassment, basically, of an individual.
Yes.
Because obviously, so really, under the scope of the legislation that we oversee, as I've said before, that the recording, the processing of that data wouldn't actually be a breach of any data protection legislation. Whether or not that would end up being a breach of any other legislation, I don't know.
Yep.
But specifically under
data protection
legislation, it wouldn't be. So really, they couldn't say, an organisation couldn't say you need to take that down because of data protection legislation.
Yeah. So that is my understanding. That's correct, and that's my understanding of the situation. Unless it's targeted or vindictive in a manner, but any organisation that has customer relations or has a customer-facing agent, they can be recorded without their permission, and they can be publicized just like any person on the street can be recorded and publicized, as long as it's not targeted or classed as stalking. That may be, like infringing the person, where they may feel intimidated and stuff, where they're being selectively. But any organization all organizations do have a customer profile or a customer facing, and they can be recorded, they can be published, as long as that individual is not being selectively targeted or selectively victimized or selectively meant to feel intimidated. That would be the crossing the line. And I understand that. But if it was just simply for the purposes of, like, for myself, what I often do is I record things and I upload it just for the general public's attention. So that would not be, I'm not doing anything unlawful there. And with regards to it being, that there is a fine line between civilians recording, like in my personal capacity, and an organization doing it for professional purposes. So if I'm just an average Joe civilian recording things that I find interesting, like this conversation I find very, very interesting. I'm sure a lot of people wouldn't find it interesting. I find it very interesting and intriguing and fascinating. I record this, I upload it to my YouTube channel. The YouTube channel is not monetized. I'm not making any money from it. All I'm looking to do is just share some interesting facts and figures. I'm not doing anything wrong there. I'm not a data controller in that regards, because I'm not making any money. I'm not doing it for commercial benefit. All I'm doing it is I'm just a civilian that's interested, find it very intriguing about this particular legislation, and I just want to be informing my viewership. That's all okay, isn't it?
That's fine. That's fine.
Okay, Dan. Thank you very much. You've been very helpful, and like I said, you are very knowledgeable about your understanding of the legislation, and it's been a pleasure talking to you.
And you take care. Have
Goodbye.
a nice weekend.
Goodbye.